Last year, the U.S. government spent $1.7 billion to detain 363,000 immigrants in a civil detention system of approximately 250 jails and jail-like facilities throughout the country. Detainees wait in facilities not as a criminal punishment, but for administrative purposes, while their immigration cases are being processed with the government. The immigration detention system came under scrutiny in the spring of 2008 after stories surfaced of detained immigrants who died while in custody, mostly because of inadequate medical treatment and non-existent medical standards for the system. News stories in the New York Times, The Washington Post, and 60 Minutes revealed that 121 people have died in immigration detention since 2003. Congress has repeatedly failed to pass legislation that would regulate the living conditions in the network of private and public immigration detention facilities around the country. Stephen Manning, an Oregon immigration attorney and member of the American Immigration Lawyers Association, has worked with many clients in immigration detention centers. This is his response to immigrant detention.
To begin talking about immigration detention, we really need to begin talking about happiness, because happiness is what it's about. Well, that's what I want. I'm sure that's what you want, and that's why people come to the United States. And this here is a vision of happiness. We've got, everybody's very cute. We've got giggling. They're smiling. They've got these nice little outfits on. There's the teacher that's educational. They've got games. Soon they're going to be bringing in milk and cookies. So this is a good thing. This is a good life. This is also a good thing, right? So again, it's another vision of happiness. We've got these cute little outfits, we've got games that they're playing, we've got food, people talking, and just having a great time. That this is happiness. But you're sitting there thinking, no, Stephen, I know better than that. That's really not happiness. That's detention. And that's true. That's exactly what that is. That's a $6 billion fantasy that the government has created. They've spent $6 billion on creating this detention system. They've spent so much money that they now wonder why people don't want to be detained. They're beginning to open up new facilities in southern Texas, these destination detention resorts. So life is good in detention, right? No, it's not good in detention. The government uses detention as an immigration control, the very same way that they use the numerical quota systems or the way that they use the deportation grounds. The detention, in the government's view, is primarily used to break the human spirit. Each year, the government detains hundreds of thousands of people. Every single night, there's some 32,000 individuals that are detained. $6 billion has been spent. And the detention is used to interfere with individuals' access to legal programs in the courts. 1.4 million transfers of individuals from facility to facility to facility in this sort of Byzantine world where no one knows where anyone is at any one time. This system, the $6 billion fantasy, is designed to funnel human beings, just like we funnel cattle, into deportation. So detention is really exactly the same as deportation. And so part of figuring out how do we stop deportation, how do we end this cattle drive, is we have to figure out how to break the detention cycle. How do we break the power that the government has to detain? We need to look at how the government uses detention. What is the powers that they have? The principal strategy the government uses is this program called ICE Access. And it's a government acronym like all government acronyms are. It stands for something cute, but I don't know what that cute thing is anymore. But what it means in practice is that they have these powers that they reach out to bring people into this detention system. There's 7 different initiatives that fall under the ICE Access program. We're going to talk about 3 of them. The 287G program, the Secure Communities program, and the Criminal Alien program. The 287G program that's one that gets a lot of news. This is Sheriff Joe Arpaio in Arizona, where local law enforcement become immigration officers. They get deputized through these memorandums of agreement. Secure Communities, that's the sexy program right now. That's the one everyone's talking about. That's the fingerprint automatic biometric identification system. There's a lot of dangers with secure communities. I don't want to mean to slight secure communities, but where the real power of the government and the detention system comes is in the criminal alien program. 48% of all individuals detained are detained through the criminal alien program. CAP is the workhorse of the Immigration Service, of ICE, and their detention system. Where S-Comm, Secure Communities, is about identification, finding individuals. CAP is about detaining individuals. It's about apprehension. CAP is expanding rapidly. In the year 2006, they issued about 70,000 detainees. By the year 2009, that was up to 230,000. That is a tripling of the number of individuals who have been detained over just a 3-year period. The criminal alien program is also about marginalizing people. It's not just about let's take people and detain them, but let's take people and let's make them other. Let's make them foreign. Let's make them different. And how do we do that? Well, let's call them criminal aliens. Let's call them criminals and let's call them aliens, because the term criminal aliens is intended and used to dehumanize. It's just government propaganda. And how do we know that that is government propaganda? 57% of the individuals picked up through the, quote, criminal alien program have no convictions, that they're not criminals. Because the criminal alien program is the linchpin of the immigration detention system, it makes sense for us to focus our legal resources and our advocacy resources on dismantling the criminal alien program, finding that weak link. I like to think of it as the scene in the very first Star Wars where they're trying to take down the Death Star and they're trying to find that single vulnerability. Well, can we find that single vulnerability in the criminal alien program, in this power that the government uses to detain individuals? All right, let's walk through it step by step and see if we can identify it. So how does CAP work in practice? The very first thing CAP does is it identifies individuals at booking. The criminal alien program operates without any kind of formal agreements between ICE and local jail facilities. So consequently, there's a lot of variation amongst facility to facility to facility on how CAP works. But principally, these are the 4 elements. The first is identification. Most sheriffs, or the individuals like the sheriff or the police, during a booking process, they will inquire of an individual of their nationality or place of birth. Now, this is done for all kinds of reasons, but the principal reason that they explain is that it's done in purported compliance with the Vienna Convention on Consular Notification. They do not fully actually comply with the Vienna Convention, and that's a separate issue. But the country of birth information is recorded at the booking process. And once it's recorded in the booking process, it generally becomes part of the public record. The immigration ICE has no special powers. They have no special statutory powers. They have no special regulatory powers. They have nothing other than the fact that they call themselves ICE that allows them to get access to this information, the booking information. They stand in the same shoes as the public. If the information is public, they can get that information. Or they have arranged through special courtesy arrangements, agreements through the local jail facility to get that information. So one law enforcement agency to another, sure, we're going to help you, you can get information to this. The country of birth information is transmitted to ICE based on some local policy, or ICE looks it up, or ICE just guesses at it based on the names in the registry. Once ICE has the country of birth information for a place, other than any other place in the United States, that detainer is lodged. A detainer is what's called an ICE hold. We'll talk about it a little bit in what a detainer is in practice, but it's important to understand at what point the detainer is lodged. The detainer is lodged prior to any legal determination that an individual is in fact deportable, or that an individual is in fact here in the United States in violation of the law. That detainer operates in practice to create a freeze on that individual, so that individual will remain in custody and that detainer will keep that person in custody. The detainer is generally on a particular form. It's called ICE form I-247. We've seen detainers that are oral, we've seen detainers that are electronic messages, and we've seen detainers written on other forms of documents. Some have just been hand scrolled. There's a new detainer form that is in the works, that is undergoing review and may be released for public comment shortly. But the present detainer form is this form that's being shown right now, and it's in 2 parts. The first part of the detainer form explains the interest that the government has in the named individual. The second part is the request. Let's talk about this request being critical language. The language on the detainer form is very confusing, because even though it begins with the word "it is requested," they then state that federal regulations require that you detain the alien for a period not to exceed 48 hours. The request, in quotes, this detainer form, then marshals local law enforcement, marshals your sheriffs, marshals the police at local dollars to detain and maintain custody over a foreign-born individual until ICE can take custody. So the detainer is the key link in the detention net. Without it, And in spite of the billions and billions and billions of dollars that ICE has spent in building this detention facade, ICE could not detain but just a fraction of the people that it presently does. The detainer is custody. The detainer leads to deportation. A couple important things to understand about what a detainer is not. So first, a detainer is not an arrest warrant. There has been no probable cause to demonstrate that a detainer should be issued. It is merely issued on the say-so or on the personal belief of an individual officer. A detainer does not grant bond jurisdiction to an immigration judge, so it is not considered ICE custody enough to be able to get bond authority. The detainer is not the equivalent of a criminal detainer, which is governed by special rules and a compact amongst the states. And real critical for advocacy efforts, a detainer is not reimbursed by federal dollars. The detainer has a very circumscribed purpose under law, and we'd like to talk about that. So let's take a look. Section 287D of the Immigration and Nationality Act was created by the Anti-Drug Abuse Act of 1986, and it's where the detainer first came into being. Prior to this time, there had been no statutory authority, no statutory language, no regulatory language, nothing that existed or even mentioned the word detainer. This section of the law, 287D, is the singular statutory grant of detainer power to ICE. There are two critical elements in the statute. First, 287D limits the detainer's power to individuals held on a local charge related to a, quote, controlled substance violation. Second, the detainer power is triggered by a local request to ICE. The statute does not authorize ICE to issue ICE-initiated detainers. The sheriff, the police, they need to make the request that a detainer be lodged. When I read this statute, what do I see? I see the statute provides this, which is the sole authority for the detainer, limits the detainer power to controlled substance violations, only where the local law enforcement agency requests ICE to issue a detainer. I've asked myself, is there a legal standard that must be satisfied before a detainer can be issued? And when I read the statute, I have to say yes, because it involves an ICE arrest so that the lodging of the detainer results in an arrest. It appears to be implicit in the statute that probable cause is needed before a detainer can be authorized. So I'm going to read that requirement into the statute. The regulation authorizing detainers is at 8 CFR 287.7. It's got the most tortured history of a regulation that I've ever known. It first came into being in 1987. There was originally two different statute regulations. One implemented the Anti-Drug Abuse Act, another implemented the provisions of the Immigration Reform Control Act. And then over time, as governments, as ICE generally does, the INS, ICE, they merged the regulations, and then they magically expanded their powers under the regulation, even though the statutory authority has remained exactly the same, has remained unaltered. The regulation has a couple critical elements. So first, the detainers must be on Form I-247. No other form or mechanism is recognized by the regulation. No emails, no phone calls, none of that matters. It has to be on Form I-247. Second, the regulation creates a 48-hour period during which an individual can be detained after detainer is issued. Third, it contains no limitation on the types of charges for which an individual might be detained. The statutory limitation that the detainer can only be issued for a controlled substance violation has magically vanished in the regulation. And finally, it makes clear that detention pursuant to a detainer is at local expense. When I read the regulation, what do I think? I think it is a vast expansion of the power granted by the statute. I think the regulation authorizes detainers for everything, not just for controlled substance violations. And I think it creates this 48-hour rule, this detention rule, out of whole cloth, even though it's completely unauthorized by the statute. So what are the problems with the 48-hour rule? There are many. First, ICE and the sheriffs routinely violate it. That's the biggest problem, that people are held for much longer than the 48-hour period. Second, the time period begins not when ICE is notified. So not when the sheriff calls ICE does the clock begin to tick. But the 48-hour begins when the charge is disposed of, when bail is posted, or when a sentence is completed. not when ICE is notified. What other problems exist with the 48-hour rule? Well, the biggest problem is that it's unconstitutional. An individual who's picked up on a Friday is going to be held for 48-hour period over that weekend. That 48-hour period does not count against the 48 hours because, as we know, when we read the regulation, Saturdays, Sundays, and holidays are excluded. And when we have a holiday that falls on a Monday or even on a Friday, then suddenly we've got a 48-hour period plus a 48-hour period plus perhaps another 48-hour period. And pretty soon we've got an individual who's been held in custody without probable cause for up to 5 days. A very similar rule was deemed unconstitutional by the Supreme Court in the criminal context. So anything here in this detainer context that exceeds the 40-hour period seems constitutionally suspect to me. When we read the regulation, it uses the words shall detain. We talked a little bit before about the detainer being a request, but then you are required to detain. Isn't that shall detain make it mandatory when a local law enforcement officer receives the detainer? Don't they have to detain? Well, no, they don't, not necessarily. Detainers are almost certainly non-mandatory. Congress has never granted the power to compel detention at local expense, and I'm not sure Congress would even have the constitutional power to do so either. The shall detain language that appears in the regulation can fairly be mean to read that the 48-hour period is the maximum period, that the regulation is protective, that you shall detain an individual no more than 48 hours. And so anytime a local law enforcement officer exceeds that 40-hour period, they're in violation of the regulation. There's some recent agency policy that makes 4 useful points for us. First, it clarifies that detainers are just a request, and that the timing begins when the foreign-born individual might otherwise be released on the local charge when the charge is disposed of. Second, the policy clarifies that the detainer can only be lodged if the individual has been arrested for a criminal violation. There had been a lot of controversy, rightly so, that local police had been involved in what we considered the phantom charge, or the problem of disappearance, where individuals would be picked up locally and never booked, never charged for any local violation, but then immediately turned over to ICE. So there was never a charge. And an individual who might have been coming home from work, next thing you know, you receive a call from them and they've been deported back to the country, the problem of disappearance. This is supposed to intended to redress that. Third, the policy emphasizes that ICE is not supposed to use that 48-hour period to the maximum. Once they lodge a detainer, they are expected to pick up that individual. They're not supposed to wait the full 48-hour period, even assuming that that 48-hour period is lawful. And finally, the policy makes it clear that special care is supposed to be given to lawful permanent residents. The detainer is the weak link. The detainer is the weak link in this entire process in the detention net. And we now need to figure out how to exploit it. Because if we can exploit this weak link, we can break the detention system. We can break the detention cycle, and we can end the detention system as we know it. Breaking that link is going to happen on 2 different levels. We take action to save individuals, your client, my client, any one individual client. And we can take actions that can change the process systemically. To save an individual, to save one person, we have several legal tools at our disposal. We have our state habeas actions. We have possible negotiation, and we have damages actions. When we bring a habeas action, what's going to prevent the ICE from immediately picking up that individual? We file the habeas, then isn't ICE just going to come and pick up this person? Maybe, but maybe we can also get some other remedies in court in addition to that habeas. Perhaps we can file a motion to a state criminal court judge seeking enforcement of the sentencing order or the bail order requiring the release. Maybe we can get a declaratory action that local funds cannot be expended to maintain custody, enforce the release. We can think creatively in our state court systems where we're going to have more power and more control than ICE will have. Another useful strategy or action to save an individual is negotiation. Negotiation can happen on many different levels. You can talk about the 48-hour rule with the local jail. You can go down to the jail, and as soon as that 48-hour period is up, you can start banging on the door to get your client released. And you can talk to their lawyers. Maybe the sheriff doesn't want to have a conversation with you, but I bet you their lawyers might want to have a conversation with you. So you can talk with their county council. You can tell them, like, look, you're breaking the law, and this is why you're breaking the law, and this is what you should do. And lawyers are going to care about the law. The sheriff should care about the law too. But the lawyers are going to see the law in a different way than the sheriff. And the lawyers are going to know what it means to be sued for money. And so the lawyers are going to take special care when you're talking about detention. And finally, you can make it about money. And money, more than anything else, is going to be what talks in this period. You can sue for negligence. They didn't respect the 4-hour period. They had poor internal control policies. They had poor record-keeping policies. They didn't start the period on time. You can sue for false imprisonment because they had no authority to detain. Or you could also sue under any kind of state law claim or a federal constitutional violation under Section 1983. And ICE is not going to come to the local jurisdiction's defense. ICE is going to take their billions of dollars and keep it for themselves, and that local county is going to be held on the hook. So how do we change the system? How do we break the system down? We can do that by challenging the regulation as being ultra-virus. So that entire regulation, the entire detainer regulation, that 90% of all detainers that are lodged in violation of the rules. And so that regulation is ultra-virus, so we can sue them to stop that. So we can sue them to say that that rule and the process is absolutely illegal. And right now there are 3 suits that are going on doing exactly that same thing in the Northern District of California, in Colorado, as well as in Florida. We can also engage in advocacy. Advocacy is taking place all across the country with local groups, local organizations. Here in Oregon, we have an organization called Safe Communities that is working with our county council, that is working with our county commissioners, that is working with our sheriffs, county by county, explaining to them this is the right thing to do. We do not want to detain individuals of our community who have not committed crimes. We do not want to detain individuals who are our brothers, sisters, neighbors, friends, and family. We want to do the right thing. And by doing that, by reaching out, we can actually create a climate where the sheriffs and the county commissioners feel empowered to say no to ICE's attempts at enlisting them at their own expense to be force multipliers for ICE enforcement strategies.